Hi, I'm Mark Mangano. I have the pleasure to be counsel with Jackson Kelly. As Jonathan mentioned, until I came back last year, I was CEO of a community bank in the northern panhandle of West Virginia. And again, my practice is primarily banking and then strategic planning facilitation. But the genesis of my comments today are not from my legal practice. The genesis of my comments come from that experience as a community banker. We were kind of an interesting little shop in Newell and Chester, West Virginia. We were a community development financial institution, designated so by the U.S. Treasury. And that meant that one of our primary purposes was to serve distressed economic communities and find economic development opportunities for the populations in those communities. Our solution to that was coming up with a mortgage lending program that helped generational renters, usually people of modest means, to buy a house, pay for it within 15 years, and have it cost them less than the local rental rate. So win-win-win sort of situation. My reflection on consumer protection law came as I watched the mortgage crisis unfold and the regulatory and legislative aftermath of that crisis. And I came up with 4 observations. First, what I think are or should be the goals of all good consumer protection law, but also that the way we make the law tends to favor limited perspectives. And when we favor limited perspectives, we tend to undercount the cost of the mitigation solutions we come up with. And when we undercount the cost, we tend to risk doing harm to the very people we're setting out to protect. So let me talk about what I think the goals are. The goals for consumer protection, I think, are very simple. The first is we're trying to mitigate a harm or potential harm to a group of consumers. And the second goal is that we should do that at the least possible cost. And I have a broad definition of cost. It's, everybody, depending on where you're sitting in the room, it's my cost. Costs are spread around. They can be really fun, hard dollar costs, increased fees for consumers or increased compliance costs for financial institutions or limitations of business models for other vendors. It's also societal costs, increased tax expenditures to support a regime to provide oversight. Potentially sometimes reduced productivity because we are starting to limit activities. So in looking at those costs, why do I think that we are undercounting it? Why are we seeming to favor limited perspectives? Let's think about how we wind up making law. First thing is somebody perceives a risk or a potential risk that needs to be mitigated. A group comes together, comes up with a solution, presents it for legislative or regulatory action. Once that happens, who shows up? Whoever is immediately and significantly impacted by that solution. So the mitigation proposal is on the table. If my ox is going to get gored, I'm there, going to protect my interests. And what usually seems to happen is you start to get a binary conversation, and us and them. What are we going to do? How are we going to negotiate our way to something that the legislature can pass or the regulators can issue? I think what's important is who doesn't show up regularly in the legislative or regulatory process. First, you have the people who don't see that they are going to be immediately impacted by the rule. They don't really see how the new mitigation strategy is going to affect them significantly, so they don't think to come and show up and become part of the debate. And I think the even more significant group that doesn't show up are people who are really going to be impacted significantly, but lack the resources, the awareness, the organization to effectively participate in our legislative and regulatory scheme. What I'd like to do is give you an example of what I'm talking about, and this comes from my background at the bank. We're all familiar with the Dodd-Frank Wall Street Reform and Consumer Protection Act. A piece of that dealt with mortgage lending, and it created something called the Qualified Mortgage Rule. And the Qualified Mortgage Rule gave safe harbor to lenders to avoid significant litigation risk if they made loans within that qualified mortgage rule. And the mortgage rule, very simply, is two things. You'll limit how much you're going to charge your customers in interest and fees, and you won't lend people more money than they can afford to repay. There's a certain limit on debt to income that the customer can have, and if you do those two things, essentially, you get to put your loan in the safe harbor. If you choose not to, significant litigation risks. You do it at your own risk. As a practical matter, most banks were not going to make anything but a qualified mortgage loan after Dodd-Frank was implemented. So with that, let's think about what perspectives won out in that day. Who was at the table? Well, the first perspective was mortgage borrowers shouldn't be abused on the amount they have to pay for their mortgage loan. There was a lot of that going on in the lead up to the mortgage crisis. The second was that people shouldn't be allowed to borrow their way in, and lenders shouldn't be allowed to lend their people into positions where they were going to be unable to repay the loans. Pretty good stuff. And everybody understood that we were going to be starting to limit the activities of both lenders and the consumers we were going to protect. That's okay. That was on the table. That was the debate. We all acknowledged that that limited societal limitations. It slowed down the housing market. It changed a lot of things. But everybody had that. That was fairly debated and on the table. Now I'd like to share with you a perspective that I'm certain was not at the table. And that's the perspective of people of modest means. They would offer a different perspective on the qualified mortgage rule. They would tell you that I understand, because I'm not like rich people. I sometimes am going to be late because my life is closer to the edge, and then I'm probably going to have to pay a higher interest rate for the accommodation that lenders are going to have to give me when that happens to me. But if I can own my home within a reasonable period of time, 15 years, and I can pay less than it costs me to pay a landlord down the street, I'm okay with paying a little more interest rate than the qualified mortgage rule says I should. Second is that in my world, if I've got a car loan and you count my rent as debt, I'm already over the qualified mortgage rule debt to income ratio. So given that nobody's going to make somebody of modest means a loan with a non-qualified mortgage loan, and I'm not going to qualify for a qualified mortgage, you have just shut me out of the American dream. I am legally essentially foreclosed from participating, even though it was a better deal for me than not getting the loan. So that's my example of how we set out to help people. And in fact, Congress understood it. Within 6 months of enacting Dodd-Frank, they came back with a limited set of exceptions, one of which our bank took advantage of. We were a community development financial institutions. We were exempted from the qualified mortgage rules with respect to rate and debt to income. But that reached a very tiny sliver of the population. 7 years on, just last year, Congress finally gave some additional relief in allowing community banks that agreed to hold the loan that they made for the life of the loan till the end, took all the risk with the customer, didn't sell it off to somebody else, that they would be permitted to be exempted from that debt to income ratio requirement of qualified mortgage and still have the protections. So we're all aware that almost every law passed has unintended consequences. And my question is, do we just need to live with that? Or is there something we could do that might be better? I think it's naive to think that we're going to make laws any differently than we do. The same people, issues going to come to the table, the people that can see they have an economic or significant interest are going to show up and be part of that debate. One thing that encourages me that there might be some solutions out there, so there might be an opportunity for us to improve on how we're doing this so that we're creating lower cost options when we're achieving the mitigation that we want to achieve and doing it more cheaply, is something like the Consumer Law Center. What if we could create a forum to examine existing or future legislation that brings a multidisciplinary approach to examining the process, as opposed to the us and them sort of binary conversation that we wind up usually having in the legislative process. We have groups that come together, represent those groups that don't tend to show up, craft legislative advice, regulatory advice, thought leadership in a way that broadens the appeal and eliminates or diminishes the unintended consequences and saves society a great deal of cost. That's what I have for today. I've certainly enjoyed being with you. I appreciate your time and attention. Thank you.